Hello, everyone, and welcome to Legally Speaking, a criminal law web series presented by Aitken Robertson Criminal Defense Lawyers. My name's Phil Stiles. I'm a former Crown prosecutor. I'm a criminal defense lawyer now, and I'm your host for today's show. Episodes will be streaming live every Thursday of each month and can be seen on our Facebook page and also our YouTube channel. Now, the episodes will always stay on those channels, so if you miss a live stream, don't worry about it. You'll be able to tune in later. My guest for today is Stuart Rudner. He's an employment lawyer, and he's a mediator. Now, Stuart's spoken at length about cannabis legalization and about potential repercussions in the workplace, and this is a hot topic. Stuart, welcome to the show, and thanks so much for joining us.
Phil, thanks for having me. I'm really excited for the conversation and looking forward to hearing your perspective on the cannabis issues that we're going to encounter over the next few months.
Oh, yeah. It's fairly straightforward in criminal law. You know, smoking small amounts of personal use marijuana is going to become a legal activity. But here's the thing. This one narrow change in the criminal law will have endless repercussions, and the ripple effect is huge. And one area of law that this affects most definitely is employment law. So many questions come up. So I just had a question for you right off the bat. Our topic for today, it's called smoke breaks and toke breaks. So why don't we start right there? Okay, so let's say I'm at the workplace. I want to go smoke some marijuana. I see other people smoking out in the parking lot. They're smoking cigarettes. I've got my small amount of marijuana, which is now legal. Am I going to be able to just go out and have a smoke?
Yeah, the short answer, Phil, is probably not. But to give you a more detailed answer, first of all, I do need to clarify a really common misconception. There is no such thing as a smoke break in Canada. And smokers don't get more breaks than any other employee, although in practice they often do. And frankly, it frustrates all of their colleagues. The reality in Canada is everyone is entitled to a certain number of breaks each day, and whether you use it to smoke or eat or talk or go for a walk or surf the net, it doesn't really matter. You don't get any more breaks. So that's one point. To your question about can you sort of pop out to the parking lot and smoke a joint and then come back into work, first of all, my understanding is that within Ontario, the government is going to pass legislation concurrent with the criminal legislation, which will say that you cannot smoke in public places. As well as in workplaces. So your employer is perfectly entitled to have a policy that says you cannot use cannabis or smoke in the workplace, subject to any need to accommodate, and you can't go in the parking lot and smoke, same way you can't go down the street or on the front steps or on your neighbor's front porch or anything else. So that's one question I've had. And just to your starting point about how there's so many questions, I have to say this. It's probably been about 2.5 years now where I've been doing presentations on cannabis in the workplace, and I've been from the East Coast to the West Coast. It's been fantastic. Started off talking about medicinal cannabis when that was sort of the big thing, and then of course as soon as the Trudeau government announced they were going to legalize recreational use, that became the big things. And now I'm talking about both. I've probably learned more than I've taught because I've spoken at conferences with doctors, medical professionals, benefits providers. I've learned a lot more about, first of all, how cannabis can be used medicinally without causing any impairment at all, which is contrary to the common misconception. But also just about, the effects that cannabis can have on someone's ability to function or do their job. And so we're spending a lot of time, and our firm is working with a lot of our clients, both on the employer side to figure out what this all means. And we've also worked with a lot of employees who either want to know what it means or have ended up in trouble and are not sure how to handle it. So we've helped quite a few of them as well.
Right. I'm interested that I'm guaranteed a certain number of breaks per day. I find that very interesting. I barely get time for a granola bar when I'm in court, let alone the idea of heading out and taking a break and having a cigarette.
Yeah, I hate to say this to you, Phil, but as a professional, we don't get breaks. We also don't get overtime.
Very good. Stuart, I'm interested in the hiring process. So will employers be able to ask candidates, like let's say I'm applying for a job, right? Is an employer going to be able to ask me about my previous marijuana use and whether I'm smoking marijuana currently?
Yeah, that's a great question, Phil. And I say that because it's a question I've been asked a lot theoretically. But in my view, and maybe I'll stand to be proven wrong, is it's rarely going to be asked in an interview. I don't know a lot of HR professionals. I work with HR day in and day out. I don't know many who are going to ask as part of an interview, do you smoke marijuana? Do you use cannabis? Whatever. I mean, it's the same thing as alcohol, right? Alcohol has been legal in this country since the days of Prohibition. I don't think there are a lot of interviews where out of the blue, the interviewer says, by the way, do you drink? So I think it's a bit of a red herring as to whether it's going to be a real issue. But I mean, to answer your question, yeah, it's certainly open to an employer to ask. And you start to get close to human rights considerations. And just by way of background, I mean, human rights legislation in every province in Canada prohibits discrimination on the basis of specific prohibited grounds. And there are things like race and gender and religion and disability. So disability would apply, for example, if you have an addiction to cannabis.
Right.
Is one. So that's one point. The other point, though, is that you cannot discriminate on the basis of a record of offenses. And Phil, you would understand this better than I do, but it's a criminal world. But record of offenses includes criminal convictions for which you've received a pardon, or also minor, provincial offenses like Highway Traffic Act issues. But you can discriminate against someone on the basis of a conviction for other criminal matters. And in theory, you could discriminate against someone if they did say, yes, I smoke cannabis, or I use drugs, or I drink. In theory, you could. I just don't think it's going to become a significant issue.
I'm really interested. I just picked up on one thing you said. Difficult to so you can't discriminate based on an addiction. This is going to be a hot topic. Suppose I do have an addiction. Suppose I'm addicted to smoking marijuana in the same way someone might be addicted to drinking alcohol. When it comes time to let me go, how are employers going to deal with that issue?
Yeah, that's also a great question. It's an issue we deal with all the time, whether it's alcohol or whether it's cannabis or any other kind of discrimination. I mean, so what the laws provide essentially is that you should not be prohibiting someone from working or terminating them because of a disability. It doesn't matter if we're talking about a broken leg or cancer or an addiction. The theory is the same here. You have a duty as an employer to accommodate the person up to the point of undue hardship. That's one of those concepts that is very ambiguous, and judges usually say they know it when they see it. But the point is this: employers will have to incur some quote-unquote hardship. So the example I usually use is the employee in a wheelchair. And let's say you've got an employee who is perfectly able-bodied. They're in a car accident. They're now going to be in a wheelchair for, I don't care whether it's a month or 5 years or forever. Right. As an employer, you can't simply say, oh, we can't have somebody in a wheelchair. We're on the second floor. We don't have an elevator. Sorry, but we're done. You will have to assess whether you can accommodate them. And what that means is not just the knee-jerk reaction I often see, which is, oh, we can't do that. It's to really look at what the options are. And I should take a step back. It's kind of obvious if someone's in a wheelchair, but let's talk about someone with an addiction. How is that going to impact their ability to do their job? And if it's not going to impact that ability to do their job, it's a moot point. It doesn't matter. But if it will, let's say that they are addicted and they expect to be impaired a certain amount of time, or they're using cannabis medicinally and they're going to use it every day at 3 o'clock. Well, you're going to know that for that period they may be impaired, and maybe you move their shifts around, or they have an addiction, they need treatment, give them a leave of absence. The employer is going to have to assess all the options, look at the costs in terms of money, also safety considerations. And one of the big things with cannabis that we never used to talk about when we talked about undue hardship is there a safety risk? And you're not going to be expected to have a safety risk to the individual, to their colleagues, to the public. That's going to be undue hardship. But can you find a way to accommodate them without that safety risk? If you really can't as an employer and you've documented all those steps, then you may be well within your rights to say, you know what, we can't have you here anymore. But until you go through all those steps, the assumption will be that you have to allow them to continue working and make them able to do so by eliminating whatever barriers exist.
Right. No, that's very interesting. I mean, let's look at the big picture in terms of how this is going to work out in policy. Are employers going to be able to implement these blanket policies that deal with the issue of impairment by drug? How realistic will it be to enforce these policies?
Yeah, I mean, within our firm, our team has been working with employers probably for at least a year now, but intensively for the last few months, as we now know that marijuana is going to be decriminalized in October. We're working with a lot of our clients to update their policies. And, the starting point, I often get this question, can't we just have a one-line policy that says essentially, thou shalt not consume or be impaired by drugs or alcohol at work, period. So that's the starting point. And I always say that's a good starting point. But then you've got to evolve that to the need to accommodate. And as to your point earlier, Phil, if they have an addiction, you're going to need to accommodate that, or at least go through the process of assessing whether you can. Also, those policies are far too simplistic. So as I say to clients all the time, you may well have employees now who drink as part of their job. You've got salespeople. They're wining and dining clients.
Right.
Technically, if that's what your policy says, they're breaching the policy every time they do it. The same time, when you talk about medicinal uses and employers are just flipping out because they hear cannabis, they hear marijuana, and they imagine their lunchroom is going to become a drug den, essentially. And all of a sudden, we need a policy. And what I often say to them is, you know what? You probably have employees already who are coming to work and they are using codeine or other prescription medication that could cause impairment. And you've never even given that a second thought. So now's the time. Now's the chance to update your policies, have a provision in there that says if you are using prescription medication that might cause impairment, you have an obligation to disclose that, and we will then assess how we can accommodate you. If you don't disclose it and you end up being at work and impaired, you'll be subject to discipline. So that's one important part of any policy that we're putting into our clients' policies at this point.
That all interesting leads to another issue for me. Okay, so I probably can't take a break on a recess in court and head out and smoke a joint, particularly anywhere near the judge's chambers. But let's be frank. What about the rest of my life? I'm outside so I finish work. I'm going home. It's my own time. What about any policy that might impact the rest of my life, like a workplace policy that would say, for example, just a hypothetical, you're not to smoke marijuana outside of the workplace, or maybe even drug testing. How's this going to play out?
Yeah, so when we're talking about off-duty conduct, I mean, the starting point to us is always what you do on your own time is your own business. That's the default. But like almost everything else, there are exceptions. So you can't stop there. So, I mean, I talk a lot about discipline and dismissal, and I've written a book on just cause for dismissal. It's called You're Fired. Nothing to do with Donald Trump. It was written well before he became president. The book's about this thing because A, I like to talk about it, but B, it's a really complicated area. And there's a whole chapter talking about off-duty conduct. And in the last couple of years, I mean, most of the cases are on social media and how people get themselves into trouble by posting stupid things online. But the same principles apply, which is the starting point is what you do on your own time is your own business. But right. If it either impacts the employer negatively, i.e. hurts their reputation, or it impacts the employment relationship, you're online slagging your manager and they now are uncomfortable managing you. If it has any negative impact upon the employer or the employment relationship, then it is fair game for discipline, up to and including dismissal. So to your point, if there's a policy that says you can't smoke, marijuana off duty, it's up to the employer to justify that it's a reasonable policy or rule. And I think most times they're going to have a real hard time doing that. But if they can show that it's legitimate or a bona fide occupational requirement, then they may be able to.
Right. Now, I'm not an employment lawyer, but I think that so much is going to hinge in terms of the reputation to the business. I think so much is going to hinge on that stigma that marijuana carries. I go out on my own time, even, on a Friday, meet an associate for lunch. I might have one beer with lunch. Not the same for marijuana, certainly. And I certainly know that, lawyers in general tend to consume alcohol as much as or more as in any other profession. Lawyers are going to have to be a lot more careful about marijuana. And I think that issue of reputation to the employer so much is going to hinge on the way the courts interpret that stigma that it carries. And it may take a little bit of time for the stigma to dissipate a bit. But yeah, a really interesting issue. And so thanks, Stuart.
No, I think you're absolutely right. I mean, you said, it takes time for the stigma to dissipate. All I could think of is as the smoke clears, we'll have a clearer sense of what's going to happen. But the reality is social norms often drive legal policies. And we wouldn't even be having this discussion if cannabis was not more acceptable now than it was 10 years ago. Justin Trudeau would never have campaigned on a platform of legalization if it wasn't becoming far more socially acceptable. So to your point, if an employer is going to fire someone and say they were seen smoking a joint and that hurt our reputation, they're going to have to prove that within today's social context. And I think in most cases, that's going to be difficult. Now, that being said, if they're working for an anti-drug organization, then I think they might have an argument. In the same way, if you're working for the Liberal Party, but you're out there campaigning for the Conservatives, there's nothing inherently wrong with campaigning for one party or the other. But if you're doing something to undermine your employer, yeah, that's going to have a negative impact. But if you just say, look, we're a law firm, we're a manufacturing company, whatever the case may be, and we can't have our employees seen out there smoking a joint, I think it's going to be a hard argument for the employer to make to say that that's just cause to fire them.
Right. No, I agree. And I don't think we're at the stage where we're going to have Aitken Robertson rolly papers, but I do agree with you that the stigma is starting to kind of wear off a little bit, and it's just a matter of time before marijuana is perhaps going to be treated right along the same lines as alcohol. Stuart, listen, we've got we have a wide audience, lots of people out there with lots of questions. I'm interested in what you think are the really salient questions and the most common questions as well that you're getting from people about marijuana use in the workplace and the impacts in terms of its implications for employment law.
Yeah, it's fascinating to see, and you've touched upon a couple of them. I mean, what I found from the employer perspective, it's just widespread fear, and fear based upon misunderstanding. Like I said before, there's this image that some employers have: the lunchroom is now going to become a drug den, and I have to allow them to smoke up at work, and they're going to have their munchies there and bad TV reruns on the TV. That's the impression people have. Or we've got a fleet of trucks that we send out, and now if someone's using, cannabis medicinally, I've got to let them get behind the wheel when they could be high. None of that is true. It's a complete overstatement. So a lot of what we're doing is really just explain to our clients what this means and what it doesn't mean. So questions that we are getting from employers, how far do we have to go to accommodate? If someone has a prescription to use cannabis medicinally, does that mean that we have to let them come to work when they're impaired? And the simple answer is no. As I said before, you've got to assess whether there will be impairment, because of course you can use cannabis in a number of ways that will not cause impairment at all. So it may be a non-issue, but even if they are ingesting it in a way that does cause impairment, then you can assess whether it impacts their ability to do their job. From the employee perspective, one of the interesting questions that we're getting quite often is, one of them you asked, and the other, which is, I have an addiction. What do I do? Do I tell my employer proactively, or do I hope they never find out? The other question we're getting is, I have a prescription. Do I tell my employer, or I'm worried my employer is just going to freak out and fire me if I tell them. And that gets really touchy. And we've worked with a number of clients. We're working with a few now who are going through situations like that. One of the things that we often tell them, though, is if you think it's going to be an issue, be proactive and tell the employer. The employer has a duty to accommodate, but they can't accommodate if they don't know. And there have been a bunch of cases already where people have been fired because they were impaired at work, and having issues, not performing properly, making mistakes, etc. And after they were fired, they said, well, wait a minute, hold on. I have an addiction, or I have a prescription. I was using it to treat my pain from cancer treatments. You can't fire me. And a few of those have actually gone before the courts already. And in almost every case, the employee has lost because the employer did not know that there was anything to accommodate. So the biggest or most important point we're making to our employee clients, or the questions that we're asking getting from employees: be proactive, be upfront, disclose. Worst case scenario, if your employer does what you fear and they say, oh, you're using cannabis, we don't care what for, you're out. Well, now you've got a really strong claim to make. Right. So you've lost your job, unfortunately, but you will have legal recourse.
Stuart, I'm fascinated in the issue of assessing impairment, because in the criminal law context, system is struggling with how we're going to assess whether someone is impaired by marijuana. I mean, right now we have the drug recognition experts. They have a 12-step test that they do. There's all kinds of issues in terms of it being flawed science, and whether these drug recognition experts are indeed experts. In the office, how is it going to be determined whether somebody's impaired or not?
Yeah, that's a question. You asked me about common questions. That's the other one. We get that all the time. And I'm certainly no expert in gauging impairment, whether it's caused by alcohol or drugs of any kind. But from my view, it's far more simplistic than this. We know that for alcohol, we have a breathalyzer. The science is there. It's proven to show that someone's impaired or not. But you know what? Most employers that I know don't have breathalyzers in the office. And yet they are still disciplining and dismissing people for being drunk at work. How do they do it? It's common sense. You see an employee who is stumbling around, slurring their words, acting in a way that's very different than usual, you know something's up, and you can use your best judgment. And that's all that's required of an employer. You don't have to prove beyond a reasonable doubt. This isn't your world, Phil, with
right.
that level of proof.
An employee who might be going through bags of Doritos without any explanation. You have to keep a really good eye on your employees for sure. I get that.
Yeah. It's a judgment call, and it's like anything else. You, as an employer, if you're going to discipline or dismiss someone, you're going to have to show that you had good reason to form the conclusion that you did. Kind of like a case from a couple of years ago where somebody was fired for smoking. In that case, smoking cigarettes within company property. And what happened there is, it was very simple or very typical. Where there's smoke, there's fire. There was smoke wafting out of a cubicle in the washroom, and one person came out. And so the manager thought, well, that person came out. There was smoke, probably them, and approached them. And the smell of cigarettes was extremely strong. And they were, in that case, disciplined. And because they had a lengthy record, they were fired. And they sued on that basis and said their claim was that it wasn't me. And the judge, again, civil context, so not proof beyond a reasonable doubt, but on a balance of probabilities. And judge essentially said, where there's smoke, there's fire. The employer had very good reason to think it was you. You'd breached the policy. Therefore, the termination was upheld.
Wow. Another idea could just be to keep a bag of stale chips in the cupboard, and whoever goes for them first, you're gone.
I like your ideas. I'm going to come visit your workplace.
Right. Listen, Stuart, this has been a great discussion today. I'd like to thank you for joining us. You're obviously a wealth of knowledge and really interesting discussion topics. For more information about Stuart and his practice, you can visit www.rudnerlaw.ca. That's www.rudnerlaw.ca, or follow the Facebook and Twitter and LinkedIn. The LinkedIn is @RudnerLaw. Our next episode will be on Thursday, September 6th at 12:30 p.m. And we'll be having Lauren Davis. She is an attorney in Denver, joining us to discuss how the justice system has changed in Colorado following cannabis legalization. A reminder that all episodes will be live on air at 12:30, available to watch free at any time after that. And you can just tune into Facebook or our YouTube channel. We want our viewers to get the most out of the show, that's for sure. So we strive to educate people and provide helpful resources. Check our social media feeds, website, our blogs, video, LinkedIn. We're on all of the above. However, just a disclaimer and a reminder that anything you hear on the show is not to substitute formal legal advice. So please, if you have any questions, just call in. It's 1-800-668-1657. Happy to help you for a free consultation of 30 minutes, answer any questions you've got. This has been great. Thanks so much, Stuart.
Great. Thanks for having me, Phil.
See ya. Bye.